There's a single step in an Illinois underinsured motorist claim that most insured people never know about, and skipping it ends your ability to collect additional compensation permanently. It does not matter that you did everything else right. If you settle with the at-fault driver's insurance without following the exact notification procedures Illinois law requires, your UIM claim is gone. Hi, I'm Jason Marker, a car accident attorney here in Illinois who has spent 25 years helping injured people recover every dollar of compensation that they're entitled to, including the dollars sitting in coverage that most people forgot they have. Underinsured motorist coverage is protection that kicks in when the driver who caused your accident had insurance, just not enough of it. In a state where the minimum policy limit is $25,000 like Illinois, and serious accident injuries cost many times that, UIM coverage may be the most important financial protection you carry, but assessing it requires a precise sequence of steps that most people and even some attorneys get wrong. In this video, I'm going to walk you through exactly how Illinois underinsured motorist coverage works, how the math on your claim actually gets calculated, and the consent to settle requirements that has cost injured people their entire UIM claim when they got the sequence wrong. Under 215 ILCS 5/143A2, the requirements for underinsured motorist coverage require that whenever you purchase uninsured motorist limits above the state minimum, UIM coverage bridges the gap between what the at-fault driver's insurance pays and the full value of your damages, up to your own UIM policy limits. So here's what that means in practical terms. Suppose the driver that rear-ended you has $25,000 in liability coverage. Your medical bills, your lost wages, and your pain and suffering total $120,000. That driver's insurance pays the $25,000 limit. Your underinsurance motor coverage then covers the gap, but only up to the amount by which your UIM limits exceed what you already collected from the at-fault driver's policy. So if you carry $100,000 in UIM coverage and collected $25,000 from the at-fault driver, your maximum UIM recovery is $75,000, the difference between your coverage limit and what you already received. That gap calculation is built into the statute, and it's why carrying higher UIM limits pays off when injuries are serious. This is the part that matters most. Before you accept a settlement from the at-fault driver's insurance company and sign any kind of a release, Illinois law requires that you notify your own UIM insurance of the proposed settlement and give them the opportunity to respond. Under 215 ILCS 5/143A2, your UIM carrier receives written notice of the proposed settlement amount, and they have 30 days to either consent to the settlement, advance that same amount to you themselves, or preserve their subrogation rights against the at-fault driver. If they do nothing within 30 days, consent is considered granted and you can proceed with the settlement. If you skip this step and you settle with the at-fault driver first by signing a release before your UIM insurance is notified, then you've likely destroyed your UIM claim entirely. Your insurance subrogation rights were extinguished without their consent, and Illinois law courts have upheld UIM denials on exactly this basis. The settlement felt like good news, but the release killed the rest of the case. This is not a technicality buried in fine print. It's a specific statutory process that must happen in the correct order. Notify your UIM insurance in writing before you accept anything. Get their written consent or let the 30-day clock run. Then proceed with the settlement. That sequence is non-negotiable. Illinois UIM policies can include an exhaustion clause, language that requires you to fully exhaust, meaning collect the entire available amount from the at-driver's liability coverage before your UIM coverage becomes accessible. This does not mean that you have to sue the at-fault driver. It typically means you must have obtained a settlement or a judgment that reflects the full limits of their policy, not a partial settlement. What this means practically, if the at-fault driver has $25,000 in coverage and you settle with their insured for $18,000 because that's what they offered your UIM insurer, they may argue that you did not exhaust the at-fault driver's policy, that you left $7,000 on the table, and deny your UIM coverage and reduce it accordingly. Your policy language controls this, which is why reviewing your declarations page before you make any settlement decisions is essential. The right sequence and series in underinsured motorist cases is: establish your full value of your damages first, confirm the at-fault driver's policy limits, Notify your UIM carrier of the proposed settlement and obtain consent. Let the clock run. Collect the at-fault driver's full limits, then pursue your UIM claim for the gap. Doing these out of order at any point creates risks that range from reduced recovery to complete forfeiture of your claim. Everything said in the previous videos about uninsured motorist claims applies here also. Your own insurance company processes your UIM claim, and your own insurance company's adjuster is trying to minimize what they pay. They'll dispute that your injury is severe enough. They'll challenge causation. They'll argue about future medical costs and offer less than the case is worth. Being their customer for years does not soften that dynamic. Illinois UIM disputes that cannot be resolved by negotiation go to binding arbitration under the policy terms. Arbitration is a legal proceeding with its own rules, deadlines, and evidence standards. Unlike a jury trial, there is no appeal, the merits in the most cases. Unlike a jury trial, there is no appeal on the merits in most cases. The arbitration award is the final number. Preparation matters enormously, and so does having someone who knows how to present a UIM claim to a neutral arbitrator rather than a sympathetic jury. One more thing that surprises most people. Illinois law at 215 ILS 5-155 authorizes courts to award attorney's fees and a penalty up to $25,000 against an insurance company who delays a valid claim that's found to be vexatious or unreasonable. Insurance companies know this, and in cases where their exposure is clear, this provision creates a very meaningful incentive to resolve rather than drag out the process. An attorney familiar with UIM claims knows when they have to invoke it. Pull out your declarations page today. Find your UIM policy. If they match the state minimum of $25,000 per person, and you are seriously injured, that coverage may not be enough to fully bridge the gap, even after the at-fault driver's policy pays. Illinois personal injury attorneys generally recommend UIM limits of at least $100,000 per person. Increasing those limits costs very little in additional premium and can be the difference between a financial recovery and financial ruin after a major accident. If you already have a claim involved with an underinsured driver, do not accept anything from their insured. Sign any release or even verbally agree to a number without first contacting your own UIM insurer in writing. The consent to settle requirement is not optional and it's not forgivable after the fact. Get the notification out, document that it was received, track the 30-day clock, and let an attorney guide you through the rest of the sequence. You now understand how underinsured motorist coverage works in Illinois, and the consent to settlement requirement that ends more UIM claims than anything else. If the other driver who hit you had no insurance at all rather than too little, then the rules are a little different. And there are specific steps that you need to take in the first hours after the crash before coverage becomes unavailable. I covered all of that in my previous video, An Underinsured Driver Hit Me. Now what? Watch that next one and make sure that you have the full picture on both types of coverages. We'll see you over there.